Welcome back to Ben's Bench. It's Pride Month, and today's topic is the Supreme Court's LGBTQ jurisprudence. The Supreme Court has decided a handful of cases in the LGBTQ context, and today I'm going to take you through them, the good and the bad. The first case to address gay people was a 1986 case called Bowers versus Hardwick. And in that case, the Supreme Court was faced with the constitutionality of a Georgia statute that prohibited any two people from engaging in sex that was non-vaginal, and that applied to anybody. So men and men, men and women, or women and women. The case arose because in Georgia, police had observed a man in his own home having sex with another man, and he was charged under this statute. When it got up to the Supreme Court, the court quite disparagingly said that there is no right of gay people to have sex with each other because there is no protection of the family that is relevant in this case that would be relevant in other cases. And it was very sort of dismissive of the idea that gay people could in fact experience intimacy and have families. This was the beginning of a belief that the state could really do just about anything to gay people, because what's worse than making them criminals? 10 years after Bowers versus Hardwick, though, the second major LGBTQ rights case came to the Supreme Court. This was the case of Romer versus Evans. It dealt with an amendment to the Colorado Constitution prohibiting anti-discrimination provisions that would protect people on the basis of being lesbian, gay, or bisexual. In other words, this amendment would have said, in Colorado, it shall be legal to discriminate against people on the basis of their same-sex attraction. In Romer versus Evans, in an opinion written by Justice Anthony Kennedy, the first of a series of 4 that we'll be talking about today, said that Colorado cannot do this. Though Romer failed to specify exactly how closely a court should scrutinize LGBT-related laws under the Equal Protection Clause, it did say that if equal protection means anything, it means that a state cannot just disadvantage a whole group of people just because it doesn't like them. Now, although the case of Romer versus Evans is important and means that a government can't discriminate against people that it simply doesn't like, it didn't really grant anything. The next case, also authored by Justice Kennedy, did. In Lawrence versus Texas, there was a similar factual background to Bowers versus Hardwick. Police observed 2 men in the privacy of a home engaged in a sexual act, but the difference was the statute itself. In Texas, the statute said that it was a crime for 2 people of the same sex to engage in sexual relations. Remember, in Georgia, it was a crime for anyone to do that, whereas in Texas, it was a crime only for 2 people of the same sex to do it. The court had to address the question of whether this statute was unconstitutional under the Equal Protection Clause, that is, discriminating against same-sex couples and not opposite-sex couples, or more broadly, whether Bowers versus Hardwick should be overruled. Justice Kennedy wrote that, indeed, Bowers versus Hardwick should be overruled. Essentially, they found that it was based on flawed premises of historical fact and law, and that it was not the right outcome for the case, both in 1986 and in 2003 when Lawrence was decided. This was an important turning point, because there were places where gay people were essentially presumptive criminals. And now that that is not allowed anymore, it was a massive win for the LGBTQ community. The next important case was United States versus Windsor in 2013, 10 years after Lawrence. In that case, 2 women legally married in Canada and then lived in New York for many years. And eventually, one of them passed away, leaving her entire estate to her surviving spouse. This is important because federal estate tax law exempts estate taxes when the surviving spouse is the beneficiary, or the heir. So when the surviving wife paid the estate tax and then sought a refund, she was not allowed to get it because of a federal law called the Defense of Marriage Act, which stated that for federal law purposes, a marriage will only be considered a union between one man and one woman, irrespective of where the marriage was performed, what the law of the state was at the time that the marriage was performed. For federal purposes, only marriages consisting of one man and one woman would be recognized, and that is why she was not able to get a refund of the estate tax. In the third of four opinions that we'll talk about today, written by Justice Kennedy, the court said that this was not acceptable. There was evidence in the legislative record that this law was motivated by animus, by dislike and moral disapproval of gay people, and no legitimate governmental basis could overcome that motivation. So to recap where we are now, Bowers versus Hardwick is out the window because of Lawrence versus Texas, so states cannot criminalize same-sex sexual behavior when it is consensual and between adults, and states cannot discriminate against gay people just because they don't like them, and the federal government has to recognize lawful marriages that were conducted in states that allow same-sex marriage. This brings us to the fourth and final Justice Kennedy opinion, Obergefell versus Hodges. In this case, a number of same-sex couples and two men whose same-sex partners had passed away brought suit in their states to force those states to recognize their marriages or grant them marriage licenses. By the time it got to the Supreme Court, there were two legal questions that the court had to resolve. One was whether states had to license same-sex marriages, and the second, really only applicable if the answer to the first question was no, whether states had to recognize marriages that were legally performed in other states. Now, we all know what the holding was in Obergefell versus Hodges. Same-sex marriage must now be the law of the land. But it wasn't decided in a vacuum. There were many cases before that that dealt with the importance and the fundamental nature of marriage. There was Loving versus Virginia, and that case wasn't about the fundamental right to interracial marriage. It was the fundamental right to marriage. There was Zablocki versus Redhale, which was about the fundamental right of people to get married, not the fundamental right of deadbeat dads to marry. It's been established in the prisoner context as well. It was acknowledged that the opposite-sex nature of the marriage in those cases was assumed, but that doesn't necessarily mean that that's the only thing that can ever be considered marriage. Gay people also raise children. They have emotional ties to their partners. They need hospital visitation benefits and tax benefits. All of those things that apply to opposite-sex marriage also apply to same-sex marriage. The court also acknowledged the evolving role and place of gay people in society. In fact, one of the quotes from the opinion acknowledges Lawrence, where the court struck down sodomy bans, and says that outlaw to outcast may be a step forward, but it does not achieve the full promise of liberty. What does that mean? That the case of Lawrence versus Texas, though great for gay people, now they can't be criminalized, doesn't necessarily mean that that's the end of rights. So now the war is won, right? Same-sex couples can get married and they have all the same benefits to marriage as everybody else, right? Wrong. There was a joke, well, maybe joke isn't the right word, but a saying, that gay people could get married on Saturday and fired on Monday, meaning that unless a state specifically had one, there were no federal anti-discrimination protections for gay people. That changed as well a few years after Obergefell versus Hodges in a case called Bostock versus Clayton County. There, in an opinion written by Justice Neil Gorsuch, kind of surprisingly if you ask me, the court said that the provision against sex discrimination in Title VII, that it shall be illegal to discriminate because of sex, also applies to sexual orientation and gender identity. Now, the logic here is that it had been established that because of sex or because of race or because of religion or whatever, meant if that were different and everything else the same, would the person still have been fired? So in the case of a gay employee, you have a man who is attracted to men and he's fired on that basis. Now, if the man were a woman who was attracted to men, would she be fired on that basis? No. So that is discrimination because of sex. And of course, it would be the same for a lesbian. The same logic, of course, extends to a trans employee. An employee who identifies as a woman but was assigned male at birth is fired. So, what do you change? You change the sex assigned at birth. Would an employee who identifies as a woman and was assigned female at birth be fired? No, she would not. That also is discrimination because of sex. And while this case didn't specifically deal with them, there are several other federal laws that prohibit discrimination because of sex, such as the Fair Housing Act and Title IX education laws. The Affordable Care Act prohibits discrimination because of sex. So even though nothing so far has been decided in that area by the Supreme Court, the same analysis applies. Now, make no mistake, it is still possible to defend against the application of non-discrimination law, and the Supreme Court has recognized that against gay people twice. One of the cases was Hurley versus the Irish American Gay, Lesbian, and Bisexual Group of Boston, which I admit I did have to look up because it's a long name and I didn't memorize it, involving a parade in Boston. The Supreme Court there said that the parade was speech under the definition of the First Amendment, and applying anti-discrimination law and requiring this group of gay Irish Americans to march in this parade would change the parade's message in a way that the organizers didn't want to. So the parade organizers were actually allowed to exclude this gay, lesbian, bisexual group. The second time this was allowed was when the Boy Scouts of America expelled a scout leader who came out as gay. Again, the Boy Scouts' message was one of exclusion of gay people, so forcing them to welcome him back into their ranks would have changed the message of the group in a way that they felt would have been incompatible with the message they wanted to send. What's next for the court? Who knows? There hasn't been much in the way of trans rights and nothing under constitutional trans rights, so maybe that'll be next. Or maybe there will be more litigation on behalf of non-binary individuals. I don't know where it's going to go next, but it's definitely something to watch in the coming years. As different sexual orientations and gender identities are becoming more visible, they're going to get more attention from the judiciary. And one final thing that I'd like to leave you with is that social change is notoriously slow. So a loss may not be conclusive. It ebbs and flows. So if the Supreme Court does at some point rule against LGBTQ people, that doesn't necessarily mean that the game is over. Just look at Bowers versus Hardwick. That was a loss. But 17 years later, the tide's turned. Well, that's all I had for today. Happy Pride, everyone. And until next time, we're adjourned.